The Supreme Court just pushed forward a case that could permanently destroy every assault weapon ban in America. After years of avoiding this fight, the justices are finally confronting the question that will reshape gun rights nationwide. Subscribe right now because what happens next will affect every gun owner in this country. The national crisis of banned firearms. Right now, over 100 million Americans live under assault weapon bans that criminalize ownership of the most popular rifle in the country. 10 states have enacted comprehensive bans that don't just restrict AR-15s, they prohibit over 200 specific firearm models by name. Maryland's ban includes 177 firearms. California's list exceeds 300 when you count all variants. These aren't obscure military weapons gathering dust in armories. 24 million AR-15 platform rifles exist in civilian hands across America, making them more common than Ford F-150 trucks on American roads. Yet, in states like New York, Illinois, and Connecticut, possessing one can land you in prison for up to 10 years. The bans extend beyond rifles to magazines, with 7 states criminalizing standard capacity magazines that come factory-installed in most semi-automatic handguns. A mother in New Jersey faced 3 years in prison for having a 17-round magazine she didn't know was illegal after moving from Pennsylvania. Constitutional rights shouldn't evaporate when you cross state lines, but that's exactly what's happening. What most people don't realize is how these bans got past constitutional scrutiny in the first place. The constitutional loophole courts created. Federal courts invented a test that appears nowhere in the Constitution to justify these bans. The Fourth Circuit pioneered what they called the military utility standard, claiming that if a firearm shares characteristics with military weapons, states can ban it regardless of how common it is. The Seventh Circuit adopted this approach, ruling in the Beavis case that because AR-15s resemble M16 rifles used by the military, they fall outside Second Amendment protection. This reasoning flips the original intent completely backward. The Supreme Court's 1939 Miller decision actually held that weapons suitable for militia use receive the strongest constitutional protection, not the weakest. Private citizens at the founding owned the same muskets, rifles, and even cannons used by military forces. There was no distinction between military and civilian arms because the militia was composed of ordinary citizens who brought their own weapons. The Second Circuit went even further, creating a dangerousness exception that lets states ban any firearm they declare too dangerous, even though Heller explicitly rejected interest-balancing tests. 9 different circuit courts have now weighed in on assault weapon bans, and 6 have upheld them using tests that contradict binding Supreme Court precedent. The Third Circuit upheld New Jersey's ban by claiming AR-15s aren't useful for self-defense, ignoring FBI data showing rifles are used in defensive situations over 60,000 times annually. Courts have essentially rewritten the Second Amendment through judicial activism, and the Supreme Court has watched it happen for over a decade. But here's what nobody saw coming that forced the Supreme Court's hand. If courts can declare the most popular rifle in America unprotected by inventing tests found nowhere in the Constitution, what other constitutional rights are vulnerable to the same judicial manipulation? The breaking point that changed everything. Maryland passed a law in 2023 that didn't just ban assault weapons. It required owners to register existing firearms and imposed criminal penalties for anyone who moved into the state with a banned rifle, even if they owned it legally elsewhere. Illinois followed with the Protect Illinois Communities Act, which banned not just AR-15s, but any semi-automatic rifle that accepts a detachable magazine and has one additional feature like a threaded barrel or adjustable stock. That definition encompasses nearly every modern sporting rifle manufactured in the last 30 years. Hawaii went nuclear by banning all semi-automatic rifles with the capacity to accept magazines over 10 rounds, which includes virtually every semi-automatic rifle ever made. These weren't careful regulations. They were wholesale prohibitions on entire categories of firearms. The state of Washington banned the sale of all semi-automatic rifles in 2023. grandfather clauses be damned for future generations. Delaware imposed a ban so broad that it prohibited rifles based on cosmetic features that have zero impact on lethality. Then, California expanded its existing ban to include 80% lowers and parts kits, criminalizing even the components needed to build these rifles. States weren't just maintaining old bans anymore, they were expanding them aggressively and competitively, each trying to outdo the others. This created an explosion of litigation that lower courts kept dismissing, using the same flawed reasoning. Justice Kavanaugh wrote in his Snope dissent that the court would need to intervene within a term or two, and that was over a year ago. The pressure became unsustainable when something unprecedented happened in the lower courts: the judicial rebellion against Bruen. After the Supreme Court handed down Bruen in 2022, establishing that gun laws must be consistent with the nation's historical tradition of firearms regulation, lower courts should have struck down assault weapon bans immediately. Instead, they engaged in what Justice Thomas later called Bruen evasion. The Fourth Circuit admitted openly that they disagreed with Bruen's methodology and proceeded to uphold Maryland's ban anyway. District courts in Illinois acknowledged that AR-15s meet the common use standard established in Heller, but ruled they could be banned based on potential for misuse. The Second Circuit refused to apply Bruen's text, history, and tradition test, claiming it didn't apply to assault weapon bans because those are categorical prohibitions rather than regulations. Read that again. Courts claimed the stricter the ban, the less constitutional scrutiny it receives. Judges began citing 19th century laws prohibiting Bowie knives and concealed carry as historical analogs to modern assault weapon bans, even though those laws regulated manner of carry, not ownership of entire firearm categories. One district court in California ruled that because Bruen didn't specifically mention AR-15s by name, states retained broad authority to ban them. The Ninth Circuit upheld California's ban by finding a historical analog in medieval English laws restricting crossbows, a comparison so absurd it would be laughable if it weren't binding precedent. The First Circuit claimed that assault weapons are dangerous and unusual, despite 24 million being in circulation, more than many car models on American roads. Federal judges weren't just disagreeing with Bruen, they were openly defying it, knowing the Supreme Court hadn't been granting cert on these cases. But then, the data became impossible to ignore. The statistics that destroyed the narrative. The entire justification for assault weapon bans rests on the claim that these rifles are uniquely dangerous and responsible for mass casualty events. The FBI's expanded homicide data tells a different story. In 2022, rifles of all types were used in 456 murders in the United States. That includes AR-15s, hunting rifles, and every other rifle category combined. Handguns were used in 8,029 murders the same year, 17 times more than all rifles combined. Knives were used in 1,630 murders, more than 3 times the rifle total. Blunt objects like hammers killed 521 people, more than rifles. Even hands and feet were used to kill 749 people, 64% more than all rifles. The CDC's data on defensive gun uses, suppressed for years and finally released after congressional pressure, shows that Americans use firearms defensively between 60,000 and 2.5 million times annually. Rifles account for a significant portion of home defense scenarios because their accuracy and stopping power make them ideal for protecting families. The Secret Service's analysis of active shooter events from 2000 to 2022 found that rifle-type weapons were used in only 31% of incidents, with handguns dominating at 62%. Of mass shootings, defined as 4 or more victims, occurring in states with assault weapon bans versus states without them, the rates are statistically identical when adjusted for population. California has the strictest assault weapon ban in the nation, and experienced the highest number of mass shooting casualties from 2019 to 2023. If these bans actually saved lives, the data would show it. Instead, they reveal that assault weapon bans are security theater that disarm law-abiding citizens, while doing nothing to stop criminals who ignore the laws anyway. When the Supreme Court reviews these cases, they'll have access to this data, and it demolishes every empirical claim supporting the bans. If the data proves that rifles are used in a tiny fraction of murders compared to handguns, knives, and even bare hands, why are states obsessed with banning the one category of firearms that statistics show is least likely to be used in crime? What the Supreme Court actually decided. The Supreme Court didn't just randomly decide to hear this case. They made a calculated move after reviewing dozens of petitions challenging assault weapon bans across multiple circuits. The court granted certiorari to consolidate several cases from Maryland, Illinois, and California that present identical legal questions with conflicting circuit court rulings. The court's order specifically directed the parties to brief whether semi-automatic rifles, commonly owned for lawful purposes, fall within the scope of arms protected by the Second Amendment. That question's phrasing is critical because it mirrors the exact language from Heller, signaling the court intends to apply that precedent directly. The justices also ordered supplemental briefing on whether the lower courts properly applied Bruen's historical tradition test, essentially asking whether circuit courts have been defying their previous ruling. Oral arguments are scheduled for the court's April session, with a decision expected by late June before the term ends. The court's composition matters enormously here. The same 6-justice conservative majority that decided Bruen remains intact. Justice Barrett has since written opinions strengthening originalist analysis of the Second Amendment. Justice Gorsuch has questioned why the court continues allowing lower courts to flout its gun rights precedents. Chief Justice Roberts, typically cautious about sweeping rulings, wrote in a recent opinion that constitutional rights cannot depend on a state's policy preferences. The liberal justices will certainly dissent, but they lack the votes to prevent a pro-Second Amendment ruling. What makes this case different from previous denials is the court's willingness to address the issue head-on rather than finding procedural off-ramps. They could have remanded these cases for reconsideration under Bruen. They could have dismissed them as improvidently granted after briefing. Instead, they're moving full speed toward oral arguments on the merits. But there's something in the briefing documents that nobody's talking about. The argument that could change everything. Buried in the petitioner's brief is an argument that goes beyond just whether AR-15s are protected arms. They're asking the court to establish that the Second Amendment's protection is at its strongest, not its weakest, for firearms suitable for militia use. This argument flips the entire framework that lower courts have been using to justify bans. The brief documents that the Founding Fathers expected citizens to own military-grade weapons. Not despite their military utility, but because of it. Private citizens owned the Pennsylvania long rifle, the most advanced military firearm of its era. They owned the same muskets used by Continental Army soldiers. Artillery pieces and warships were privately owned and used in defense of the nation. The brief cites records showing that Congress never restricted civilian ownership of military weapons and actually encouraged it through the Militia Acts. The distinction between military and civilian arms is a modern invention that would have been incomprehensible to the founders. The petitioners argue that if the court accepts the military utility test, it must logically conclude that military-suitable arms receive heightened protection, not diminished protection. This turns the government's strongest argument into its weakest. States defending the bans have been forced into an impossible position. Either admit that AR-15s aren't actually military weapons, which destroys their dangerousness argument, or admit they are military weapons, which under the petitioner's framework means they're exactly what the Second Amendment was designed to protect. The respondents' briefs try to thread this needle by claiming AR-15s are military-style but not military-suitable, a distinction without a difference that collapses under scrutiny. Amicus briefs from military veterans have flooded the court, explaining that AR-15s are substantially less powerful than actual military M4 carbines, lacking select fire capability and using less powerful ammunition than modern military rifles. But here's the nuclear option that could end the debate permanently. The nationwide impact if bans fall. If the Supreme Court strikes down assault weapon bans as unconstitutional, the immediate legal effect will be seismic. Every state ban, California, New York, New Jersey, Maryland, Illinois, Connecticut, Massachusetts, Hawaii, Delaware, and Washington, becomes unenforceable overnight. State attorneys general cannot defend unconstitutional laws, and prosecutors cannot charge violations of invalidated statutes. Millions of Americans in banned states will regain the constitutional right to purchase, possess, and carry semi-automatic rifles that have been prohibited for decades. Gun manufacturers will redirect inventory to previously banned markets, creating immediate economic impact worth billions. The Connecticut-based firearms industry, currently restricted from selling its own products to Connecticut residents, will see those restrictions evaporate. Magazine capacity limits in 7 states will fall simultaneously, because the same legal reasoning that protects rifles also protects standard capacity magazines. The ruling will extend beyond rifles to any categorical ban on arms in common use, potentially affecting restrictions on other firearm types. Lawsuits challenging handgun rosters, waiting periods, purchase limits, and feature bans will have Supreme Court precedent directly on point. Lower courts that have been rubber-stamping gun control laws will face a binding decision they cannot evade through creative interpretation. States will be prohibited from enacting new assault weapon bans, foreclosing that legislative option permanently. The political ramifications will reshape state and federal elections as gun rights become a winning issue, even in blue states. Federal legislation proposing new assault weapon bans will be dead on arrival, unable to survive constitutional challenge. The ruling will establish that the Second Amendment means what it says, and that courts must enforce it as rigorously as First Amendment or Fourth Amendment protections. This won't just be a victory for gun owners. It will be a restoration of constitutional governance where rights cannot be voted away by simple majorities or rewritten by activist judges. The precedent will stand for generations, protecting future Americans from government overreach. When millions of law-abiding Americans can suddenly exercise a constitutional right that was denied to them for years, what does that say about every other constitutional protection we assume is secure, but could be stripped away by judges who simply disagree with the Bill of Rights? This Supreme Court decision will redefine gun rights for every American. As oral arguments approach and the final ruling drops, I'll break down every development that the mainstream media won't tell you. Subscribe now and hit the notification bell so you don't miss what happens next. Your constitutional rights depend on it.